Yes, Mr. Gupta.
Your Lordships, may it please your Lordships, I represent, together with my learned junior, Miss Jones, the mother in this matter, the appellant, and the respondent father is represented by my learned friend, Mr. Gratian, Queen's Counsel, together with his learned junior, Cleona Papazian, Miss Cleona Papazian. And obviously this is an appeal from a decision of Mrs Justice Theis from the court below. You have a number of bundles which I'll take you through in a moment. Apologies for the plethora of bundles, apologies for solicitors not being able to agree the contents thereof, but I think I can make short shrift of at least one of the bundles, so you don't really have to look at it. There's the core bundle, of course,
Yes.
which has within it some of the documentation from the trial bundle, which my instructor solicitors thought the practice direction meant that they had to put into the relevant documents, put into the core bundle. There's the appellant supplemental bundle, which contains the rump of the trial bundle, which is not something I need to refer to on behalf of the appellant. There's the respondent's supplemental bundle, which has within it the trial bundle in the normal format. My learned friend will refer to what documents he says are relevant from the respondent's supplemental bundle. There's two more bundles. A very small bundle, which is a fresh evidence bundle, which is a few pages, which I'll refer to in due course.
Well, if you get permission.
If I get permission, some of which is irrelevant. And there's only
Well,
2 or 3 pages.
You'll have a bit of a struggle with that, then.
Yes, indeed. 2 or 3 pages may be relevant.
Okay.
And there's the recent developments bundle, which Mrs. Justice Judd, a couple of days ago, wanted this court to be apprised of.
Okay.
Which
Well, I'm for my part, well, I think for all of us, we're not particularly impressed with the way these bundles have been filed. The rules are very clear about bundles. We only need to look at bundles that are relevant for the documents relevant for the appeal. Experience shows that we hardly ever look at any documents in supplemental bundles. And I'm disappointed that with representation of this experience, we haven't had a more streamlined and appropriate presentation.
Well, you would have had if I hadn't been away and my learned junior hadn't been away on vacation. Apologies for that.
Yeah, I'm not criticising anyone in particular, but I know how difficult it is. But
so there we are on that. If I can just mention obviously you have the skeleton submission.
we've read the documents that we consider to be.
Yes. Yes.
And we better start with any. Do you need leave to? What do you do? Applications which we've required to be made to adduce further evidence. Do you need leave to amend your grounds or not?
No, I don't need permission to amend my grounds.
And in terms of the documents, so what's your application to admit? Fresh evidence.
If I could just rewind for a moment then and say with regards to the core bundle, of course you have replacement skeleton arguments which appear right at the end of the index, and those are the skeleton arguments.
Those are the ones. Those are the ones we. Well, I think
grateful.
We've been working
yes,
from.
Thank you. When it comes to the fresh evidence bundle, you'll have seen.
I've looked at this electronically, and I mean, I looked at it in paper the first time.
Fresh evidence. Number one is maybe just a point of information. I don't think it's
Is this, well,
that the mother has a residence permit in this country now, and her asylum has been granted.
well, so what is your application to admit fresh evidence?
Our application is to admit fresh evidence in relation to the inability of the mother to get a visa to go to Germany.
Which part of your appeal does this relate to?
This relates to the last ground, I believe.
13B ground.
Yes. If I can just turn up.
So all this material relates to that ground, does it?
Yes.
And why wasn't this put before the judge?
Well, these are essentially the father said he would assist the mother in gaining a visa to go to Germany, and the father has produced a one-line letter subsequent to the judgment. This is subsequent to the hearing. So does it come under the fresh evidence regime in any event, ladder martial principles in any event? But it is a subsequent letter which the father has produced, which is very short, which doesn't assist the mother in getting a visa. We say that's frustrating the process that Mrs Justice Theis thought was going to be in place to allow the mother to go and visit child in Germany once child was returned. So it's a subsequent event.
So in the light of that development, you say this material, which was not put before the judge, is now relevant to this appeal so far as the last ground is concerned.
Yes.
Okay. Is this application opposed? We've looked at it, de bene esse.
Yes. My Lord, it's opposed really for two reasons. Firstly, directions were made by Lord Justice Moylan as to when this material was supposed to be produced, which envisaged that the father would have an opportunity to respond to it. The mother did not produce any of this material in accordance with the directions that were given. In fact, the bundle of material that you now have before you was received, I think, by us yesterday, possibly Monday.
Right. Remind us, when did Lord Justice Moylan direct that it be filed?
The 11th of August, I'm told.
And when did you? We got it this week, I think. When did you get it?
I think we received it yesterday.
Okay. Filed and served this week. That's over 3 weeks late.
Yes. My Lord,
and you have not had a chance to reply to it, therefore.
No.
Of course, one reason that may be because of other developments.
Well,
okay, but leave that point for the moment.
Yes. My Lord, the second reason
Yes.
is that in my submission it doesn't actually go to the ground of appeal at all.
Okay. Let's look at the ground of appeal. The replacement ground.
The replacement ground of appeal.
8.
Yeah.
Well, is it 7 and 8?
7 and 8, yes, big part.
I mean, what? I read into this an implied appeal against the judge's decision under 13b. It's not spelt out, but that I think is what is meant by 7 and 8. That's why I've read it.
My Lord, it may...
Actually, I put my mind, is this an appeal on the 1313b? Assuming that's what it is, the judge was wrong to resist the defence under 13b.
Well,
Wrong to refuse the defence of 13b because 7 and 8.
Yes. In that regard, Mrs Justice Theis had before her an opinion from a German lawyer setting out the basis upon which, from an immigration perspective, this mother could return to Germany. The German lawyer's suggestion, which was the basis upon which, so I'm told, and so the undertakings that Mrs Justice Theis accepted from both parties suggest, was that the mother would apply for something called a family unification visa to return to Germany for, I can't remember off the top of my head exactly how long that allows for, but for an extended period of time, and on the basis of which the mother would be able to return and apply for certain benefits, including financial support and housing benefits. And the parties' undertakings were crafted on the basis of that advice. So the father offered to provide her with support for housing and financial support until such time as she had obtained the benefits to which she would be entitled if she applied to return on the basis of that visa. What the mother...
Mr. Gresham, sorry, you've said return 4 times. Had she lived in Germany?
No, she hadn't lived in Germany.
When you say return to Germany, do you mean go to Germany?
Go to Germany. I'm very sorry. I fall into that language because, of course, what we're considering is the return of the child to Germany.
The child did live in Germany, but it was my understanding his mother has never lived in Germany.
No. My Lord, you're entirely right to call me out on that, and I apologise for using the incorrect language in that regard. If one substitutes return in everything I've just said for travel to, I think the point remains. What the mother, in fact, did was to apply for a visitor's visa, which is similar, on our understanding, to a visitor's visa to enter this jurisdiction. It has a time limit of 6 months, and when one enters on a visitor's visa, there is no entitlement to benefits, whether that's financial support or housing support. As a consequence, evidence, the undertakings that the father had given in relation to financial support were fundamentally changed in their intention. The father had offered financial and housing support on a closed basis until the mother made applications for benefits that she would otherwise be entitled to. And that is where the negotiations of the circumstances under which the mother would travel to Germany, returning with her the child, really fell apart. And, Lord, in my submission on that basis, this is really an issue that should have been returned and should still be returned to Mrs Justice Theis by way of consideration of implementation of her return order. Because what needs to be sorted out is how this mother can, from an immigration perspective, travel to Germany to be with the child there. She having confirmed in the course of her oral evidence before Mrs Justice Theis that if a return order was made for the child, she would travel with him.
Okay, thank you. Mr. Gupta, what do you say in reply?
Well, your lordship has picked up that point about return to Germany. She's not been to Germany before. She didn't want to enter into some kind of immigration device, having been granted asylum.
Well, can we just, rather than explaining it, there are 2 points. First of all, it's 3 weeks late and serves only a matter of a couple of days before the appeal, which meant that there had been no opportunity to consider evidence and reply if required. Secondly, it doesn't go to the grounds of appeal, it goes to implementation of the order.
Well, we would say we apologise for it being late. My client got this information as quickly as she could. The letter is dated 15th of July, which you've seen, De Benesse, which is the father's letter, supposedly in support of the application, any application for asylum, or rather for entry into Germany, if I can put it that way. And that is dated 12th of July with a covering, with a letter in response from my instructed solicitors saying, well, this isn't enough. But then events on the ground moved on in the sense that the permission to appeal was granted and then the father has done what he's done. And the father hasn't been prejudiced by this information, his own letter being produced to him in the Court of Appeal, in this court, because he himself wrote it and he knows what the issues are. First issue being it doesn't assist the mother and it's effectively in breach of his undertaking. The second point is how relevant is it? It's all to do with the intolerability point. Article 13b, intolerability, is rather than grave risk of harm, it's intolerability. Should a child in this be put in this intolerable position of being separated from his mother? And if the court is considering that issue being remitted to the court below, this is another point, a tangential point. You may wish to consider this later. I asked the court to look at the final paragraph of my learned friend's skeleton argument.
I've read it.
Yes.
We've read it.
Yes. So if that is the case, then maybe, just maybe, there's a way forward for this matter to be remitted to the court below for a habitual residence determination.
You're moving off the point, I think.
Yes.
Okay. Anything else you want to say on the mission? Okay, so that's the first bundle. And the second bundle is the little bundle sent to us by Mrs Justice Judd. That just informs us of the subsequent developments.
Yes, indeed.
Is anybody applying for any of this material to be put before the court?
Yes, we are. We asked that the court has this. Mrs Justice Judd was clear that she wanted the Court of Appeal to be made aware of this documentation, I gather.
Okay, but is anybody, well, we are aware of it.
Yes.
In the sense that we're aware, it tells us what's happened.
Yes.
Which is obviously something that this court needs to know. But is anybody going to rely on this for any argument in the?
Yes, I am.
Okay. So why do you ask for this bundle to be admitted on the appeal?
Well, the father's subsequent steps, if the court bears in mind his undertaking to the court below, that's to say, Mrs Justice Theis, if one looks at electronic page reference 43 of the core bundle.
What's the paper page reference?
Page reference is 41 in the bottom right hand corner.
So can we proceed on the basis that electronic is 2 more than page all the way through?
Yes, thank you.
Okay, right. 41.
41.
41, 43. Right, yes?
You'll see there front and centre the father, paragraph D, undertaking not to seek to, 1, separate the respondent and child, whether by way of a custody order or otherwise. So obviously he's, because of his actions, in removing the child on the 28th, I think it was, of August, unilaterally, he's in breach of that undertaking. And that is something that the learned judge in the court below didn't think was going to happen, because of course she took that undertaking, and it sheds light on the ground 8 of the appeal, the grounds of appeal.
Okay, that's your ground for that. I think, and I'm just trying to be
Secondly,
hurry you along. Yes.
no, not at all. Secondly, the father's statement within that bundle of documentation, that's the page 36, which for some reason has turned into page 37 electronically, so we seem to have lost the page.
Hang on.
Page 36
Of
the
core bundle.
of that bundle that you just looked at, the fresh evidence bundle.
You mean the
Recent developments bundle.
recent developments bundle? 36. Yes.
This is the father's own explanation of
Yes.
what he did and
Yes.
why he did it. And if you look at the top of the page, what does he rely on? He relies on the child's views and wishes.
Forgive me, I missed the page.
Beg your pardon. Page 36.
Of the 6.
Father's statement. Now dropped off. He told me I want to go with you to Germany. So I decided to, effectively decided, etc.
Yes.
So he relies on the child's views, the child's, for want of a better word, objection to staying in England or wish to go to Germany. And we say that by doing that and claiming that in this document to the court below, he obviously relies on the views of the child, which is one of the points of our appeal, which is, with great respect, the court below, with the child of this age, should have got the views
Was there a
of the
charge?
child.
Okay, all right. I won't start debating this.
No.
That's your argument.
Yes,
Thank you.
Thank you.
Mr. Gratian, what do you say to the admissibility of this bundle?
Well,
First point, perhaps, being the stronger point.
Mrs Justice Judd, having said the court should have it, I don't at all oppose the court.
Thank you.
in considering.
Thank you very much. Right, now what other bundles what other preliminary documents do we have to? There's a
So
dispute about the-
those 5 bundles, you don't need to refer to the
Is any-
appellant's supplemental bundles.
Are you opposing the court having any of the respondents' bundle? So we're going to make a decision on these two, on the first point, because Mr. Gratian's conceded the second one. Right, just give me a minute, sit down. I don't want to bang you up the court. Trying to see what's even. Well, we deprecate the way in which the directions have not been complied with, even in August, and even in the pressures that everybody's under in the family courts. This was far too late. What we're going to do is we're going to continue to look at the Day Bennett essay and reach a form of view at the end of the hearing as to whether or not it has any real value. Thank you very much. All right.
May I just ask one issue about the undertakings?
Yes.
May?
This is the ones on page 41.
You know, it's more for Mr. Gratian, in fact. You said that the undertakings effectively were given on a basis which ended up not applying because no application was made for a family reunification visa.
Yeah.
I understood it. But the order is structured very carefully on the basis that the mother might not apply for such a visa And some of the undertakings are conditional upon her doing so, and some of them are not conditional on her doing so. So on what basis were the undertakings given on a misconceived basis?
Lord Miss Papazian, who was representing the father at the hearing, tells me that the mother's position at that stage, she having not then been granted asylum in this country, was that she was effectively leaving her position open as to what she would apply for in Germany. And it was that open-ended approach on her behalf that led to the undertakings being structured in the way that they were. My Lord, I do accept that from the drafting of some of them make specific reference to family unification visas and others do not.
Yes.
But the instructions that I have had and the information I've had from Miss Papazian was that it was clearly envisaged in the light of the expert evidence that that was what she would apply for, and that he gave his undertakings in terms of financial support and housing support on that basis, which is why when the mother applied for a different visa, he withdrew his agreement to those particular undertakings.
It wasn't an agreement, it was an undertaking to the court.
Yes.
So he couldn't withdraw it.
Forgive me, my lord. I was being spoken to while you... Can I just see what Miss Papazian was saying, and then can you ask me that question again?
Yes.
The remedy was to apply to be discharged. So the remedy was to apply to be discharged.
Or vary.
Very, yeah.
Lord, what Miss Papazian says to me is that the mother didn't apply to vary the order, didn't confirm her position in relation to what visa she was going to apply.
She didn't need to apply. She didn't need to apply to vary it. It says very clearly in terms, in the event that she intends to apply for, she must.
Yes, my lord,
The whole thing is conditional. And I have to say, if you're suggesting the father would unilaterally decide not to comply with the undertakings or threaten not to, because she didn't apply for a visa, then that's completely mistaken approach and didn't justify him doing anything.
my lord, I obviously accept that the order is drafted in the terms that it is, and, my lord, it was put as you have recited it. And, my lord, I accept the general proposition that when someone gives an undertaking, it's not within their gift simply to say, well, I'm not going to do that anymore.
Well, there's a very clear course for them to take. They must apply to the court to vary or
Yes.
discharge the undertaking. And unless they do, they're bound by it.
My lord, I accept that, of course. That isn't what happened here, but my lord, in my submission, it doesn't change the thrust of the point that I made earlier in relation to the admissibility of these papers, that these were all things that could and should have been put before Mrs Justice Theis by way of implementation. And that really is where my argument on this rests.
All right. Well, we'll leave it there for the moment. Right. Now, Mr Gupta, let's get on with your appeal.
Could I just pick up on that point very briefly and just say, of course, on the basis of that undertaking, which you see there, the mother allowed contact. And that's...
I'm sorry, the mother...
She allowed contact to happen in England. For the father to take the child for contact, knowing that he'd undertaken to the court below.
Okay, before you get started, there's one other preliminary point I
Yes.
should just mention. You applied, your solicitors applied for an order,
I think, that we ordered the father to attend the hearing.
This causes considerable research.
Consider our powers to do that. We're satisfied we had the power to do that. But in the circumstances, we were unpersuaded that it was necessary to do that for the purposes of this appeal.
Yes, and I read something that said you were going to give your reasons.
Yes. No doubt there'll be a reference to this in the judgment, but
yes.
just so you know, that's our thing. We don't consider the father's attendance to be necessary for the purpose of this appeal.
I should have said that both parties are, of course, joining by watching this.
Well, I assume that's right. And am I right in saying, Mr. Gratian, that your client was in attendance before Mrs. Justice Judd electronically earlier in the week?
Yes.
Thank you. Right.
Yes. And again, before I move on, what he says at the end of his statement in the recent developments bundle, the father's statement is paragraph 12, page 37. I wish to obtain the decision of the appeal proceedings prior to confirming my position on whether child should be returned to the applicant and to this jurisdiction.
Yeah.
It may be us on behalf of the mother, but we see that in an optimistic light. He's involved in these proceedings, albeit he has reached an undertaking to the court.
Right. He's in contempt.
He's in contempt. He is in contempt. And that must, we respectfully submit, be relevant when it comes to this appeal. With regards to...
well, just so we, in a sentence, why do you say his contempt is relevant on the appeal?
Well, of course, if one looks at Mrs Justice Theis' order, it was based on a number of, as is often the case, as always the case, in Hague Convention cases, it was based on placing reliance on the applicant's good faith and giving undertakings. And without, if she didn't have faith in the father performing those undertakings, then we respectfully submit she would have probably not made the order for return. If she'd known that the father was going to breach
All right, well,
an undertaking.
thank you for flagging that up.
Yes.
Well, let's see how you weave that into your submission.
Yes.
Right.
And so, but again, before I continue with this appeal, the last point we respectfully submit for the court to consider is whether it needs to go into this appeal because of what my learned friend has said in the last paragraph of his in his learned junior skeleton submission.
Well, that's an alternative submission.
It is an
His
alternative
principal
submission.
submission is in the penultimate paragraph.
Well, I was wondering whether it was principal and secondary fallback or whether it was alternate.
Well, let's hear how you put your appeal, Mr. Gupta.
So good. So, Your Lordships, you've seen our respectful skeletal submissions. We respectfully submit the learned judge in the court below was wrong to make the decision that she did. And it's no criticism of the learned trial judge, it's just a number of procedural errors which resulted in the learned judge's eye going to the wrong issue. In general terms, she was distracted by the loss of Ugandan habitual residence rather than the gaining of English habitual residence by the date of the alleged wrongful retention.
So she was distracted by the loss of Ugandan.
Yes, in other words, the gaining of German habitual residence, which was, if we just summarise in the chronology, what the events on the ground is the child was born in Uganda on the 13th of September 2014, was there until the 29th of April 2019, which is when he went to Germany, was wrongfully, as found by the court below, retained in Germany until the 30th of September 2020, and then was in England until very recently, the 28th of August 2022, so here for almost 2 years. And we respectfully submit that the learned judge, when she was looking at the defences, and if the court turns to her judgment, you'll see at page 45 of the core bundle her judgment. It is, with great respect, always difficult when you have effectively a double unilateral removal or retention. Because here we have paragraph 2, father's application is opposed by the mother, who defends the application on 3 grounds. Number 1, Article 3 of the Hague Convention is not engaged. The child's habitual residence was not in Germany at the time of the alleged wrongful removal, wrongful retention. What ideally it should have said, of course, is that it was in Germany, sorry, in England, at the time of the alleged wrongful retention. Instead, what happened is that debate went on into whether the child had gained German habitual residence from Uganda going back to 29th of
So
April.
is it your submission to this court that at no point was it asserted by anybody before the judge that the child was habitually resident in England at the relevant date?
I've been looking into that, and I've seen from my learned junior's skeleton submissions before the court below, and the copies don't appear in the bundles, and I can provide them if necessary. Paragraph 25 of my learned junior's skeleton submissions at the beginning of the trial before Mrs Justice Theis say as follows. I can just turn it up, beg your pardon. Your skeleton. Yes, it is. I beg your pardon, let me just... The mother asserts that child is habitually resident in England. He has lived with her since September 2020 with the consent of the father. He is settled here, living with mother and attending school. He is integrated here. That's what the written submission was. That we couldn't see anywhere, if the court looks at the learned judge's decision, paragraph 60, 59, 58 onwards, an analysis of that contention. And there's a trying to maybe over-intellectualising it, but trying to work that through. It's because the learned judge was dealing with what she thought was a consent defence rather than a change of habitual residence defence. And the academic reason for that may well be answered by what was said by the then Lord Justice Wilson in an authority called EJ, which doesn't appear in your authorities bundles, but we've got copies of that here, which is about drawing in consent within an Article 3 defence. Habitual residence, was it gained because a father consented, rather than it being an Article 13A defence. And Lord Justice Wilson on that occasion refers to it as that old chestnut. It had been referred to in the case of P before the Court of Appeal.
Paragraph 2 of the judgment summarises the mother's defence.
Yes.
Defence, overall defence of the application.
Yes.
First, the child was not habitually resident in Germany at the time of the retention.
Yes.
Secondly, the father consented or acquiesced to the child being in this jurisdiction. Thirdly, 13b.
Yes.
So reading that, it looks as though there's no suggestion from that it was part of the mother's case the child was habitually resident in this country.
Well, with great respect, what about number 1? Article 3 of the Hague Convention not engaged. Child's habitual residence was not in Germany, i.e. England.
Well, you say i.e. England, but
instead,
that isn't how it's then. The issue is considered in the judgment. The issue is considered in the judgment on the basis that the child retained habitual residence in Uganda.
Indeed. What was not put forward, save in the skeleton submission, that quotation that I've just mentioned, was, well, actually, look at the situation on the ground. Look at what's happening right now. Look at the relevant date of retention, which father says is July 2021. And consequently, if one's looking at it through that lens, then the court should make an analysis of
okay, let's go to paragraph 48 of the judgment.
Yes.
Where the mother's case is fleshed out by the judge. And this point is covered, isn't it, in particular in the last sentence in paragraph 40. It's on page 54 of the hard copy.
Yes.
52, is it? Or 6?
54.
50, I'm just looking to see, and nobody's doing electronic, everyone's on paper. 54. Last sentence, 2 sentences. Ms. Jones submits, X's habitual residence is in England, based on what she says is the agreement reached with the parties in September 2020 for X to move here to live with her. That is tied up with the defence of consent.
Indeed. So it was put in the box of consent when in fact, obviously a child, even if the consent is not made out, is still in the jurisdiction in July 2021. We respect submit because of the way it was put in the Article 3 defence was put in. The court should have looked at where the child was habitually resident at the time of the alleged retention. And analysed.
Even if it's not argued. I mean, the case you're facing
Yes.
is that you're trying to run arguments in this court that would not run below. And as my lord has just pointed out, the way in which the judge characterises the mother's case in paragraph 48 is it was said that X's habitual residence is in England, but based on the contention that the father consented to him being here.
Well, your lordship.
And then the judge says that's all tied up with the issue of consent, and then she deals with the issue of consent and finds, as a matter of fact, there was no consent, and as I understand it, there's no appeal against that.
Well, your lordship, with great respect, I entirely accept that these are points that weren't raised fully in the court below. Footnote 3 on page 7 of our risk placement skeleton submissions actually concedes that we're aware of the obstacles that stand in the way of points being run on appeal that haven't necessarily been run.
Well, do you accept that it wasn't, that the question of habitual residence in England was presented to the court judge on the basis that there had been an agreement in or around September 2020, and not on the basis of integration?
Well, I go back to what my learned junior said in her skeleton submission. He's lived here since September 2020 and it does say with the consent of the father. He is settled here, living with mother and attending school. He's integrated here. Now, with the consent of the father, it's a small c rather than a consent under the Hague Convention. It was done with his agreement that the child remain here from September through to July. And we respectfully submit that is an important point. If both parents agree a child should be in a particular country, during that time the child independently puts down roots, especially if he's growing up between the ages of 6 and 8 years old, and consequently independently becomes integrated. And
Well, that must be right in the context of retention.
yes,
Because retention can only arise, can it not, at the point at which consent ceases?
yes, indeed,
Consent with a small c.
yes, consent, indeed,
Yes.
agreement, put it that way, parental agreement. And the fact that the parents agreed to the child being in this country, as opposed to agreed to the child being in Germany, they didn't agree on that, meant that the child all the more had the validation from both of his parents to put down roots. He knew that both of his parents wanted him to be there. So that is a different point, but it is right to say, I cannot agree with what your lordship put to me just a moment ago, which is that we didn't run this integration point at the point of retention below, in the court below. It wasn't.
There's
run
nothing
fully.
about it in the judgment.
It can't be said it was run fully, but it was mentioned in the skeleton submissions. Had it been run fully, there would have been.
Were there written closing submissions?
There were written closing submissions.
Are they? Do we have those?
No, they're not in any of the bundles, as far as I'm aware, unless one of my friends can correct me.
Well, for my part, I'd like to know how it was run in closing,
Yes.
because it wasn't.
I have my junior's closing submissions right here.
I mean, let me say, if it appears that I'm being critical of counsel, I'm not. I'm just anxious to get to the bottom of how it was put. I'd like to know how it was. We'd all like to know how it was put in closing, because it wasn't. It didn't obviously leap from the page in as far as the judge was concerned.
Yes. If I could just respectfully ask the court to stand back for a moment. And
Have you got the closing? What's the answer to my question? Have you got the closing?
I've got a
submissions?
73-page paragraph document in closing.
Okay. Well,
Which,
was it asserted in closing that the child had acquired habitual residence through integration in the 10 months?
It's not expressly asserted in that way. It was expressly asserted in the
I'd like to see.
submissions.
I'd like to.
We can
Well,
get those.
it was asserted in the way that you said in the skeleton argument at the start of the case. But I'd like to see how we'd like to see how this was put by both parties in closing.
Yes.
There are in the voluminous documents that you've filed in contested bundles.
Yeah.
Has this document, which sounds quite important, been included?
It's not.
No.
It's not.
All right. Could you please,
Yes.
if you've got electronic, forward it to my clerk, Miss Derham.
Yes.
Both closing submissions now, with a note that the judges have asked for this to be brought up now.
Would you like to see the opening skeleton submissions by both
Yes,
parties?
you want to refer to that, so yes, we'll see both.
Great.
That's it. By July 2021, it seems to be the one thing which could not be contended for was that the child was habitually resident in Uganda.
Has to be.
And by that date, been in school in either Germany or England
Yes.
since 2019.
Yes. 2019.
And neither parent was then resident in Uganda. So it seems to me Uganda must by that stage have been out of the picture. So
Indeed.
any argument about habitual residence, whether on an absolute or seesaw basis, must be between England and Uganda, England and Germany.
Yes.
So it seems to me that if you were contending that it wasn't Germany, it must have been a contention that it was the United Kingdom.
Either that this child was one of those very rare children who didn't have habitual residence, which, as your lordship knows, is academically envisaged as possible by Lord Wilson in Reby, but not likely, or because of the seesaw analogy, must be England, which is why the Article 3 defence, which I pointed out in the learned judge's beginning of her judgment.
May I just interrupt you a second?
Yes.
Occasionally we're getting a lot of noise from this window, and when we
Yes.
do, I can't hear you.
I beg your pardon. So I was just saying that unless this is one of those very rare cases where a child does not have habitual residence, which is deprecated
Yes.
effectively by Lord Wilson in Reby, we'd have to be arguing English habitual residence. And that's my point. If the court's looking at Article 3 being run as a defence, it doesn't mention Uganda, it doesn't mention England, but surely it would be England if we're saying the child's not habitually resident in Germany.
Well, you say surely,
relevant time.
but for my part, I'd like to see how it was put before the judge.
Yes, of course.
Because reading Mrs Justice Theis is a very experienced judge.
Of course.
And I was reading how she analysed all this in her discussion section, paragraphs 54 onwards. She's focusing on the move from Uganda to Germany under this section.
Yes.
And that does seem to be, at any rate, that's what she says.
Yes.
The mother's case was focused on. You look at paragraph 58 on page 56 of the bundle. The courts have made it clear it's highly unusual for a child to have no habitual residence. The mother's case of X's habitual residence is not in Germany is focused on the fact that she did not agree to X going to Germany. So if that's what the mother's case was focused on, the move from Uganda to Germany, and did that stop X acquiring habitual residence in Germany, it's not surprising that that's what the judge's judgment is focused on.
Indeed, that's exactly why, with great respect, at some stage in the scale of argument, we say the judge can hardly be blamed. It's just we still respectfully submit that the wrong decision has been reached because one's looking at the date of retention. And my father's case is that was July 2021, and surely at that date the court then has to look at. Okay,
Well, but
where
you
is
see,
the
you're
child?
asking us to sort of stand back analyse the whole case afresh, or are we deciding whether the judge's decision on the case put before her was wrong? That's there is a concern up here that you're running cases that was run below. You see, that's the problem.
Yes, I understand that entirely.
So when do you say what was the relevant date of retention? That's a point you raised obliquely in your document.
Indeed, the learned judge, the father's case was July 2021. That's the date. It's in the month of retention of the father's.
And what does the mother say?
The mother's case is that my instructions were that she never actually intended to return the child, having got the child back in the.
So well, when do you say?
September 2020.
So you say the question is September 2020. And where was the child habitually resident in September 2020? On your case?
Well, on our case, it would be Uganda because the child had been wrongfully removed,
right,
as found by Mrs Justice.
So
Uganda.
There we are. That's the case which you're now running before us, and that's the case which, as my lord's pointed out, and it seemed to all of us reading it, or me reading it, that's the case that was run before the judge, and it's the very case you're running now.
Yes, but the relevant point of retention, as far as the father's case is concerned, as far as the court found, if it settled on a date, we couldn't actually see exactly where the learned judge said that was the date of retention, is July 2021, and the court had an obligation, we respectfully submit, in dealing with a case involving a child, who is the most important factor in the case, in dealing in Hague Convention proceedings, which are there to protect the child, to look at the case in the round and say, well, okay, at this point, at the point of retention, where is this child habitually resident?
So subject to seeing, for my part, I still want to see how it was put in.
Yes.
But it sounds as though you're now saying the judge accepted your submissions, Jones's submissions on your behalf.
Yes.
That the relevant date was September 2020. I don't know whether, I'm not clear whether you're appealing against that, but on the basis of that, it was on the basis of that retention date that she had to consider, first of all, habitual residence, well, that relevant, first of all, habitual residence, secondly, whether there was a wrongful detention, and thirdly, whether there was any of the defences applied.
Indeed.
So her decision was that the child in September 2020 was habitually resident in Germany.
Yes. But then...
Secondly, that the child had, what did she sign on retention? The child had been retained wrongfully.
From July onwards, the following year.
And thirdly, that none of the defences applied.
But in looking at July...
Where do we find her finding on the date of retention?
Well, that's one.
You say it's July 2020.
Yes, that's the way it was pleaded by the father, and that's the mother. That's the learned judge's decision was to accede to the father's case.
Where do we find the date of retention?
That's one of the issues that we have with the learned judge's decision, because if she'd actually stated, as of July, there has been a wrongful retention, 2021, then she would have looked at that date as the material time and said, well, I now need to look at whether the child is habitually resident as of July 2021. And had she done so, then she would have drilled down and realised that
she didn't. Okay, we're going around in circles, but
yes.
I think we've agreed that the judge found that the relevant date. She accepted your case that the relevant date was September.
I'm not sure that is right.
Really?
I'm looking at paragraph 61 to 63,
yes,
which is where she deals with it. She finds that in 61 that the original agreement was a time-limited one until Christmas 2020, January 2021.
Yes.
So up until that stage, there's no wrongful retention. And then in 62, she says the period was extended, and the end point she puts is X should attend school in Germany starting in September 2021. So it looks as if it's extended through 2021 to some time before September. It's not a very precise finding.
No.
But she does say in 63 the initial period was time limited to Christmas, January 2021, and whilst it was extended, it was always in the context that X would return to attend school in Germany. So, as I read that, she's found there was an initial agreement in January. That agreement extended, but was always subject to a cut-off in September, which looks like a finding that the retention was at the latest in September or on the father's case in July.
Yes, and in that, with respect to that, obviously having said that it's at the latest in September, let's say July to September 2021, the court then has to look, because of the Article 3 defence, has to look at whether the child was eventually resident in the requesting state, Germany, at the time of the alleged retention.
What is the Article 3 defence? Can you just explain that?
Certainly. If the court looks in the authorities at tab 1, you'll see it there set out. It doesn't require any gloss. There's no anything from counsel. Article 3 at the bottom.
So what you refer to as the Article 3 defence is the contention that the child was not habitually resident in Germany at the date of retention, is that right?
Yes, which is as set out in paragraph 2 of the learned judge's judgment, at the alleged wrongful retention.
And that comes back to the point we touched on earlier, that it appears from the way the judge put it, that she understood that contention, what you call the Article 3 defence, to be contingent on her accepting the mother's case on consent. She rejects the case on consent. She doesn't understand, and that's why we want to see the way in which it's put in closing.
Yes.
There to be a separate contention that even if the retention was wrongful and so there was no consent, the child's habitual resident had shifted from Germany to England at that date. That doesn't seem to have been put forward. And I think your contention is the court should have seized upon that issue of its own motion. Is that right?
Yes. It should have picked up on my learned junior's submission that I read out earlier on with the father's consent, child in this country. Consent, I'm going to say agreement, parental agreement, paternal agreement.
I don't see what that... I mean, that's not the question, because on the judge's finding, there was an agreement up to a certain point,
Yes.
and then it stopped.
But in the meantime, what does the child do? He puts down roots. He becomes integrated.
Yeah, no, you're arguing the case. What I want you to focus on is it the duty of a judge exercising this jurisdiction to start asking herself questions which are not being put forward by way of submission? Now, I know you say that there was a submission in opening, but if it wasn't there in closing, my starting point would be that a judge's job usually is to decide the issues argued in front of her, and when you've had a process of opening, evidence and closing, one can look at the issues which are still in play by looking at the closing submissions and seeing what the contentions are which the parties are putting forward. Now, I haven't quite understood whether your case is this was actually still in play, this issue, or whether your case is, even though it wasn't articulated, it was the judge's job to think of it for herself and answer the question for herself. And that is a different...
Yes. My respect submission is it was in play, but it wasn't pushed. It wasn't pushed as much as it should have been. So the court wasn't made fully aware of it, although it was mentioned in skeleton submissions. But secondly, with great respect, yes, the court, in a Hague Convention 1980 case, Hague Convention 1996 case, any Children Act case, domestic case, has to have whether I...
Just a minute.
Yes.
You're saying that the blanket approach applies across the board in children's proceedings, are you?
Is there any authority as to the duty of the court? I mean, I understand entirely that in Children Act cases,
Yes.
the court's focus is on the welfare of the child, and the process is much more of an inquisitorial one than a purely adversarial one.
Yes.
But the case you are facing, as I understand it, is Hague Convention cases are different. This is ordinary civil litigation in which the judge's role is to decide the issues articulated by the parties, and not to start. Not only she's not obliged to, she's not entitled to start considering other issues. That's the case you're facing.
Well, in my
So the question is, do you have any authority which says in Hague Convention cases the judge really ought to be having her own roving investigation into what's in the interests of a child?
With great respect, I'm not saying it's her own roving investigation, but I'm also not saying it's just straightforward civil proceedings. These proceedings under the 1988 Hague Convention are supposed to protect the child and promote the child's best interests within the structure of the 1988 Convention. If your lordships are looking for some route to the court having to have a weather eye on, for example, the human rights of the child, the Article 8 ECHR human rights of the child, right to a family life, which of course the court has to promote, being a public body, then we've mentioned it in our respectful skeleton submissions at page 381 of the bundle, which is paragraph 25 of the skeleton submissions, which is the Article 20 defence under the 1980 Hague Convention, which refers to human rights. Now, that's not a normal straightforward civil case. It's a case involving the human rights of the most vulnerable person involved in the proceedings, the child. And we've provided an example of how that has worked on the ground in the authority of SP and EB and KP before Mr Justice Mostyn in the court below in the past.
Right, well, parking that point for the moment.
And
Just so that we're clear, and obviously some time ago now, but I did Hague case the first instance. I don't think either of my lords have. But just so we're clear about this, presumably the practice hasn't changed that much. At the preliminary stage, the defendant is required to identify the basis upon which he or she, in this case she, opposes the application for summary return.
Yes.
And that will include whether there's an issue about habitual residence and the defence, if the child was, where was the child habitually resident? Where is it accepted that the child has been wrongfully removed or retained in breach of rights of custody? And if so, what defences under 12 and 13 he or she relies on?
Yes, and the normal...
And the court's process is focused on the way it's put by the defendant.
The court's process, with great respect, is the way the case is put on Article 3 by the applicant,
Yes.
on the defences by the respondent.
You're right to correct.
And of course, Article 3 is for the... Well, it's talking about burden of proof.
Okay, but unlike Children Act cases, where the court has a quasi-inquisitorial role, there isn't such a quasi-inquisitorial role in this case.
There can't be a quasi.
It's the judge, as my lord says, as in normal civil litigation, or other types of civil litigation, the court has to decide the case on the basis it's put before her.
I hesitate with that because, yes, absolutely, but again, and apologies to repeat myself, this case does involve a child, and the child is not represented, and the court doesn't have any independent information about the child, save for the facts. This is what's happened in the chronology of the child's life. And bearing in mind what I've mentioned about the Article 20 defence, bearing in mind what we say about the intolerability, why should the child have to tolerate being moved unilaterally from one country to another, that being a proper defence under Article 13b for reasons that we've set out in our skeleton submissions. The court, in a 1980 Hague Convention case, however the case is run by counsel for the respondent or counsel for the applicant, has to, with great respect, just pause for thought and stand back and look at the situation on the ground for that particular child at the relevant date. And hence, if the court is saying, as Mrs Justice Theis said in the court below, the relevant date is somewhere between July and September 2021, after the child has been on the ground in England, through one academic year in England, then the court, in my submission, should have paused and said, okay, what exactly is the position here with regards to habitual residence? Because Article 3, the burden of proving on the applicant, Article 3 says at the time of the wrongful removal, where the child was habitually resident immediately before the removal or retention. And so the court is drawn by looking at that Article 3 to a duty to the child. It has a duty to the child in Hague Convention proceedings. Surely it's not simply civil proceedings where a case is put and answered. And a child now who has been in this country for almost 2 years is then unilaterally removed back, of course, by the father. I sort of heard of. Do you want to? Does your lordship want to?
You make the submissions you want. Mr.
Yes. If I can just go through the skeleton submissions, as we mentioned at paragraph 22, the other parent's permission or agreement for a child to remain in any country where both parents agree to that position surely has some influence in the child putting down roots in the jurisdiction by the time of any alleged retention. When that, as Lordship said, when that consent stops, that's when the court looks at the date of retention.
We now have electronically the mother's closing submissions.
Yes.
We have all the submissions, including the closing ones. As far as I can see, there is an assertion that it's not clear when the father is saying there was retention. But there is no examination, no contention or examination of where habitual residence was as of later than September 2020. And certainly no assertion that there was habitual residence in England relevant to these proceedings.
I accept that, but it's a fact. Habitual residence is a fact that the court has to determine at the point of the alleged wrongful retention.
It seems to me that what the court has to determine is whether there was habitual residence in Germany. And there are two ways that you can attack that. You can say either the child never acquired habitual residence in Germany, or you can say habitual residence in Germany was lost.
Yes, by the time of retention.
And it seems to me that you argued the former, but did not argue the latter.
Not fully.
Well, at all in closing.
In closing, if it's not mentioned in closing, that's
I can't see it there.
My Land Junior will double check that. She falls on her sword and says it wasn't as run as much as it should have been, but of course it was there in her opening skeleton submissions and in the position statements for February and of course during the course of the evidence, which took a number of days and submissions. That's why I used the word distracted, and it's not the learned judge's fault at all, because the way the case was run was talking about Uganda and the gaining or lack of gaining of German habitual residence, as your Lordship pointed out, rather than attacking the date of retention, alleged retention, in mid to late 2021, and saying, well, the court needs to look at that.
Well, to be fair, the first paragraph of the closing says this document should be read in conjunction with the skeleton argument.
Yes.
But equally, to be fair to the father, the closing does address the evidence in some detail, but the evidence it addresses is up to the end of 2020.
Yes.
There's any mention of anything post December 2020.
I could just just bear with me one moment. If the retention on the mother's case had been September 2020, rather that she said, well, when I got the child, I was never intending to return the child. If that's the date of retention, if the learned judge had found that that was the date of retention, which of course she didn't, then that would have brought into play the possibility, because proceedings didn't start till the following, till a year after, more than a year after the child was in the this jurisdiction, that would have brought up the possibility of a settlement Article 12 defence. Because that's what the mother effectively, my understanding, was saying. And consequently, and that's why, of course, why she started Children Act proceedings earlier in 2021. She was doing so on the basis of habitual residence in England, and her basis was she wants to keep the child in England. So that kind of conduct, we respectfully submit, points towards
her position statement for the final hearing. Paragraph 11 does say, it's asserted by the mother that in the circumstances it cannot be said that she has wrongfully retained the child in the UK, and she would assert that he has habitual residence here. He now has settled status.
Yes. So, run, but not run fully.
But the difficulty is that once all the evidence has been heard, that was no longer the contention. Or not expressly.
Not expressly, because the evidence moves into father abducting from Uganda, wrongfully retaining from Uganda, which of course the mother was believed on that. But nevertheless, the court then said the child became, despite the wrongful retention in Germany, became habitually resident in Germany. And what we say is, if the court had then applied the same logic later on in 2021, it would have said, well, even though the father has not agreed to a further period, the child has been in this country by agreement all these months and has therefore gained habitual residence in England.
Can I just ask, I lag behind my lord, what passage in the closing submissions do you... It's paragraphs 9 and 9, 10 and 11 in the closing submissions, is it? I've Control F to find the word habitual, so I've got that.
Yes. Yes. He's become habitually resident.
Well, so her case, the mother's case was, never became habitually resident in Germany.
And then arguing.
Alternatively, if he did, then if it is found that despite the wrongful retention in Germany, he has become habitually resident there by September 2020, it's the mother's case that he brought H over for a holiday in the UK and then agreed to H remaining in the with you.
And that's
Paragraph 13. It is unclear whether F is saying that H was wrongfully retained in the UK. He accepted the jurisdiction of the court in the private law proceedings. If the court finds that the mother had wrongfully retained H in the UK, this is 14, then she would seek to defend the application for H to be returned on the basis of 13b. Okay. Well, this explains, for my part, this explains why the judge drafted the judgment in the way that she did. She thought that the case, in closing, the case was being put on the basis of had the child ever acquired a habitual residence in Germany? And the mother's case was that he hadn't. And that the father had consented to the child being here.
Yes, consented being the opposite.
So in other words,
capital C.
if contrary to the mother's assertion, the child had acquired habitual residence in Germany, then, although the mother had retained the child here, she'd done so with the consent of the father. That was how it was argued before her.
That's how the case
And
that's how
although-
the child developed.
And
That is
you say nonetheless, despite your appeal is based on the proposition that despite that, it was still incumbent on the judge to look beneath the surface of the mother's closing submissions, recall the alternative way it had been put in the position statement, and deal with that.
Well, look at Article 3, with great respect, for the learned judge to look at Article 3. Once she decides on the date or the period of retention, to say at that point of wrongful retention, which she found, as Lordship pointed out, July, August, September 2021, to look at Article 3 and say, well, at that point, where is this child habitually resident?
But because the point had been taken in the position paper that there was habitual residence in England, but that point is then not pursued in closing after the evidence, despite the same counsel putting forward the argument. The judge is entitled to assume, but on advice, that the mother was no longer maintaining that position. The judge can't be expected to look at and consider arguments which the mother has abandoned.
With great respect,
when represented.
with great respect, they weren't abandoned. There's a moot point. Nothing was said about them.
Well, not pursued then. If you want to.
Obviously, if something's being abandoned, if it's a key defence, and it's a fact, that the court is being asked to analyse at a relevant date.
Well, it's not a fact, is it? It's an evaluation. It's an evaluation.
Well, it's a habitual residence is a fact. It's an evaluation of a fact. We'll put it that way. And it's relevant to the Article 3 determination. Then it would be incumbent, with great respect to the court, to ask counsel, are you abandoning this point? And for counsel to stand up and say, I'm abandoning that point, that's not an issue anymore. And that would have dealt with it, but it didn't.
That seems to me to be a rather prescriptive way. I mean, it's everyday experience in courts that judges listen to what counsels say in their closing submissions and identify from that the issues that this is the judge's task is to work out what issues, whether of fact or law or discretion or assessment or anything else, am I being asked to decide and decide them.
Yes.
The judge's job generally, and I have your submission that Hagen mentions is rather different, but speaking from my own experience in ordinary civil litigation, the judge's job is not to hunt around in other documents for points that might have been at one stage in play and say, have you expressly abandoned those? It is to work out from the closing submissions, what are the issues I need to decide and decide them. And that's what judges do up and down the country, day in, day out. And I think your submission is that it's different when a child is involved.
It is different with a child involved, but it's also different when one's looking at Article 3. All the learned judge has to do is look at the defences, look at Article 3 in this case, and look at the relevant date and say, well, now I need to decide where this child is habitually resident at the date of the wrongful retention.
Yes, but there's nothing, at any rate from a brief look, which says, if you decide, as is the father's case, that consent did not extend beyond the summer of 2021, then you need to reconsider not only whether the child had acquired a habitual residence in Germany because of his stay there between 1919 and whether he had lost it because of his stay in England between September 2020 and whatever date you decide. It's just not there.
It's
And those are factual questions. Courts heard oral evidence. One would expect if that was something the court was being asked to do, that it would be asked to do it expressly. I do think it's very hard on judges to expect them to try and guess what somebody's case might be, rather than identify what somebody's case is.
I agree with that, Your Lordship. Safe to say, of course, it was set out in the skeleton argument at the beginning of, I think it was a 3-day hearing. It is a point of defence. It is child has become integrated in this country by the date of the letter of retention. And the trial judge, it was placed before the trial judge, and if counsel then didn't formally abandon that argument, then the court still had a responsibility to the child to decide whether, under Article 3, that fact had been established.
It's not just a matter of argument, though, it's a matter of evidence.
Yes, indeed it is. Oral evidence that it should have been gone into.
And the difficulty is that in the closing submission, no evidence pointing to habitual residence in England was highlighted for the judge. And is the judge meant to go back, routing back through the evidence on her own to say, well, actually, though none of this is mentioned in closing, I have got material here which suggests that the habitual residence is England.
Well,
she's got to do all that on her own, but look at the evidence, consider the evidence and the arguments. If they had been put forward, would this amount to habitual residence?
it's great respect. We again say that it's the duty to the subject of the proceedings of the child for the court to say, well, this was mentioned as an argument. Surely this should be dealt with in oral evidence.
Can I just as someone not steeped in this area of law, I just have difficulty with that contention, because it seems to me that the whole concept here is one's determining where the child should be returned to, or whether they should be returned somewhere, and then any welfare proceedings could be taken in that jurisdiction.
Yes.
And the question of interim welfare is addressed through intolerability in 13b. And it seems to me that having a test of intolerability is inconsistent with the court having to do a detailed welfare consideration.
Well, the court can't do a detailed welfare consideration within the ambit of the 1988 Convention. It's simply jurisdictional.
It is. It is.
That's what it is.
And nothing to stop the mother bringing welfare proceedings either in here or there are.
Well, they were stayed in the normal
or in
course.
Germany.
There's no welfare proceedings in Germany. She started them here. They were stayed because of the Hague Convention.
No, but the point is there can be.
At the moment, my lords have been questioning you from their own experience, but at the moment, I don't accept your proposition that the court has as wide a role, an inquisitorial role, as you contend for in Hague proceedings. Hague is a summary process. It's got to be dealt with quickly. Evidence is always limited. You don't make a welfare judgment. You have to deal with the case that's put before you. And if this court was to require judges at first, the judges of the division and the deputies who deal with this, to undertake the sort of inquisitorial, quasi-inquisitorial examination for themselves, above and beyond what's argued by the parties, then that would be a very significant additional imposition, which in my present view is not required under the convention or the rules implementing it.
Well, with great respect, Your Lordship's overstating what I'm suggesting. I'm not saying a wide-ranging power. I'm saying that these proceedings are different to normal civil proceedings, because the most important person in the case is the child, and the court has to have a weather eye on what the reality of its decisions are.
What do you mean? Have the weather eye on the reality?
Well, in a situation where the child is not represented and his or her views are not taken, which we respectfully submit was wrong in this case because of the child's age. His views should have been obtained.
We're going to come on to that. in a bit.
Yes. Then the court, as part of its responsibility, whether it's Article 20 of the 1980 Hague Convention, i.e. the human rights element, whether it's simply because it's addressing a child case, an international child case, and has a limited, but albeit still a responsibility to that child, should look at, because of Article 3, the wording of Article 3, what the fact is, whether the facts are established pursuant to Article 3, and the facts are, they have to be established are, is the child habitually resident in the requesting state at the material time, i.e. at the date of retention. And this learned judge's judgment did not deal with that as a point. It dealt with habitual residence in September 2020. It didn't deal with whether the child was habitually resident in the date, on the date of retention, i.e. July or September 2021, in Germany. And had she done so, she would have paused for thought and thought, well, actually, we need potentially some more evidence. This has been raised in skeleton submissions. This formula doesn't work. Let's have a look at that point. And that was wrong. She can't be faulted, however, because of, with a small f, because of the way the arguments were dealing with, I say, a distracting point of what happened in Uganda. But it still has resulted in a wrong decision. So it's a situation of not criticising the learned judge for her judgment, but rather the decision, with great respect to this very experienced judge. I was mentioning the getting the child's views, and of course, if the learned judge had decided that the mother was retaining the child wrongfully from September 2020 onwards, with proceedings starting more than a year later, it would have been an Article 12 defence, as I mentioned earlier, which is a settlement defence. In cases of settlement, there is an automatic Kafka's report on what the child's views are and the child's circumstances and whether the child is settled in the jurisdiction.
I'm sorry, Mr. Goodrich, I haven't understood this point. You've now twice referred to if the judge had accepted wrongful retention by the mother in September 2020. But that was not the case that the mother was running. The mother was running the case that there was no wrongful retention at all because the father's consent was open-ended. So it wasn't put to the judge. Actually, I always intended to keep the child from September 2020 without the consent of the father, and the wrongful retention happened then. Therefore, the Article 12 defence didn't arise. Therefore, the question of settlement didn't arise. Therefore, the question of a Kafka's report for the purposes of settlement didn't arise. Why were you even considering what the position would have been if your case had been different? Because it wasn't.
Well, with great respect, my client issued proceedings earlier in the year 2021. She obviously intended to keep the child in the jurisdiction long before the father.
It's not a question of what the facts are. It's a question of what your case was.
Yes.
It's similar to the previous point. The judge, certainly for my part, is entitled to look at the way you put your case. And the way, as I understand it, you put your case was there was no wrongful retention at all. Not there was either wrongful retention in July or there was wrongful retention in September 2020 or in February 2021 when we started proceedings in England. Simply, there was no wrongful retention at all. Was it suggested to the judge?
Can I just turn my back from it?
No.
It would have been in the list in paragraph 2. It would be in the list in paragraph 2.
Well, my client's position, I gather, was that she never wanted the child to go back, having had the child in her care from September 2020 onwards, he having been abducted from her, from Uganda all those months before.
If the settlement issue was one which might arise depending on
The date of retention, yes.
why wasn't it identified by the judge in paragraph 2, where she puts your client's points, summarises what the points are?
Well, again, this is why we've mentioned at page 7 of our skeletal submissions, when we mention these two defences, that these 2 points are raised on appeal and weren't raised in the court below. There's Article 20, human rights, and Article 12. They weren't raised in the court below. So they weren't raised before Mrs Justice Theis.
But is it not the case that this suggestion of wrongful retention in September 2020 is dependent upon factual findings?
Yes.
Well, we can't substitute our factual findings for the judge's factual findings, can we?
No, you can't.
So
But the question
we are
is-
stuck with the judge's finding that there was a wrongful retention in July 2021, and, or sometime in the summer of 2021, are we not?
You are, with great respect, but if it's only wrongful if the child is habitually resident in Germany in July 2021.
Yeah, but that's a separate point.
Where's the
We're
point?
now looking at the Article 12 defence,
Yes.
and the suggestion in your skeleton that it's relevant that the retention might have taken place in September 2020. But if that wasn't run below, if it wasn't the subject of any factual findings, we can't come to that conclusion because we're stuck, you are stuck, with the judge's factual findings, which are an essential prerequisite for reaching that assessment. Is that not right?
It is correct, Your Lordship.
So I go back to my question, why are we looking at what the position would have been had there been wrongful retention in September 2020 and you would have had the 1 year question under Article 12, because we're not in that position, and I don't myself see how you can get yourself into that position now.
The reason it's being raised is because we respectfully submit that had the court had it been explained fully, then the court would have looked at the date of retention either being September 2020 or later. But I entirely accept Your Lordship's point that we are stuck with the facts as found by the learned judge.
But if even if your client intended that the child would not be returned, nevertheless, the judge has found that the child was in this country by consent up to September 21, so it's not wrongful.
Indeed, and that was my client's position.
Some
Yes.
very complex argument that your client's intention vitiated the consent in some way, but
You've not appealed the consent.
No, we haven't appealed.
so I don't see how, even on your own case, you can say that consent was. You can say that there was wrongful retention in September, because even on your own case, there was at least until January there was consent, and the judge found that continued right up to summer.
Well, indeed, all I can rely on is what my learned junior has told me, which is essentially the mother never planned to return the child,
But why does that matter?
and
You may
if
not plan
the
to.
father had known that at the time, then he probably wouldn't have consented to the continuation of the child being in the country.
Well,
there we have it.
But that is quite a complicated factual
It
case,
indeed is.
which one would expect to have been ventilated in oral evidence if it was going to be run.
Yes.
And carefully considered by the judge if it had been.
Indeed.
And whether an unexpressed intention not to return the child when the consent expired vitiates the consent seems to me to be complex factually and legally.
It's almost a sort of misrepresentation case.
Yeah.
Yes, it is complex factually. It has been explained by in the Supreme Court.
It's been considered, hasn't it?
It has been considered.
If a consent was based on a misapprehension as to your
Yes.
intention.
And I can turn your lordships to that
But does that arise here though? Does it? None at this point wasn't taken before the judge. And this is all. This line of submission goes back to your point that there was really a settlement defence which ought to have been considered, or the judge ought to realise that on one reading there ought to have been a settlement defence that wasn't pleaded,
Yes.
and therefore she should have not made a decision without getting the views of the child.
what's referred to often as a child-centric defence.
Well.
We respectfully submit that these are child-centric proceedings, so something for the court to consider. But in any event, if it doesn't fall within that category of settlement, because the mother, even if she hadn't explained her decision to retain the child to the father at all, and it doesn't come within the Article 12 defence, there's still, we respectfully submit, a duty to the court to consider the views of the child.
On what?
The views of the child on summary return to the jurisdiction of Germany. Not just simply if the child is objecting, but especially if the father's own case now, as I pointed out at the beginning of the series, seems to be reliant on the child's views. Child saying, I want to go to Germany, is what the father's relying on. And so it's difficult for him to say now, well, this child's views shouldn't be taken.
Well, you're saying the judge was wrong to make a decision without asking Kafkas to speak to the child and obtain.
Yes.
The child's objection was not a defence.
No.
Children are not spoken to as a matter of routine
No,
in
they're
these
not.
cases. Kafkas' resources are extremely limited, as you know. On what basis do you say that this child's views should have been, to what end? Should this child's
On the
views-
basis that the learned judge was obviously thinking, well, this child's been abducted by his father to Germany, been wrongfully retained in Germany. This child has been living in this country for a number of months, if not over a year. And I, as the judge, again, it goes back to my restricted point. I'm not saying it's an open-ended point, but the court has to have a protective view of the child and the Article 8 rights of the ECHR rights of the child to obtain a child of this age, who's almost eight this month in a couple of weeks, or if not a week, his views on a summary return to his father's care in Germany, where it wasn't clear whether his mother could go with him.
Does this go to the Article 13b defence or to the Article 3 issue?
Well,
What is the issue
It goes
on
to
which
13.
the child's views are
Yes.
to be obtained?
It goes to the 13b intolerability. It's not a grave risk of harm. It's an intolerant. Is this something that an individual should have to tolerate, being sent back and forth summarily by a court without gaining his views?
Children are not invariably interviewed by Kafkas in 13b cases.
No, they're not.
It's a case management decision by the judge.
Indeed it is. And it was never raised, as far as I'm aware. It wasn't raised. It's another point that wasn't raised in the court below. But it goes back to my point, which I've said earlier on. The most important person in the case is the child. The court's being asked to summarily send him to a country which the court has found he's being abducted to. In that situation, on a human rights basis, this child alone, if not anything else, should be interviewing, getting an expert from Kafka's High Court team to obtain his views.
Right, so just looking at your grounds of appeal, try to put somewhere. We've dealt with what haven't we covered? We're coming on to 13b now. We've got 7a
Yes.
to do. Have you dealt with everything else?
I believe I have.
Yes.
13b, as I said before, and apologies for repeating myself, is the intolerability point. Child being in this country for almost 2 years, should he have to tolerate paragraph 24 of our skeleton submissions, page 10, should he have to be expected to tolerate a summary sending back to a country where his mother's never been, and in circumstances where the father has shown that he will breach his undertakings to this court, the soft landing provisions.
All right, well, can we park for the moment the subsequent developments And show us why you say the judge's treatment of 13B was wrong.
Yes, certainly.
Would it be helpful just to remind, now as we've got the documents, just to look at how 13B was argued before the judge in closing by the mother? Where is it dealt with in these closing submissions?
It's at page 15 electronically of the closing submissions.
Paragraphs?
Paragraphs. Sorry? Paragraph 15 of the closing submissions, which is page...
Shall I look at the right document?
Yeah, I'm just wondering whether I'm looking at the right document.
Paragraph 15 begins, the court has the benefit of an advice from an expert in German.
Yes, I think it starts at paragraph 14.
Yes, apologies.
Okay. Oh yes, there it is.
Skeleton argument.
So this was based on, well, the mother's case is,
Yes.
the mother's case was she would go to Germany, was it? If she could.
If she could, she
Okay.
would.
It's
would
not a
go to
case of
Germany.
of a child being sent to a country without the
Not a case of mother refusing
mother,
or not being able.
which happens in some cases. So
Indeed
that's
it does.
so this was a case where the child will be going with mother, and the focus of these arguments is on whether mother could go. The visa point,
Yes. And father.
the difficulties in getting the visa, the problem, the fact she's never been to Germany, the difficulties she would have making an application to the court, paragraph 21.
And I cannot place before the court any evidence of her inability to get German legal aid. It's something we mentioned in an application for fresh evidence.
Can we just, on what, given the way this was how that 13B was put before the judge, what points, why was it relevant for the judge to consider whether the child should be spoken to by Kafkas for the purposes of 13B?
If I just bear with me one moment. Wasn't raised in the court below. It again is my point of the court having a duty to the child.
Okay. All right. So what else do you want to say about the judge's treatment of 13B?
If I can just turn up our skeleton submissions. It's essentially the delay point by starting the proceedings. They taking their time. The father, of course, didn't start until the child had been in this jurisdiction for a considerable period of time. It has resulted in a delay on the ground of this child actually going back to Germany. Paragraph 24 of the skeleton submissions.
Your submission?
Yes, our skeleton submission, which is 380, page 380, printed of the core bundle. Refers to the quotation from dicta from Baroness Hale in Reedy 2006 UK HL 51, which is a delay of this magnitude securing return of a child must be one of the factors in deciding whether the summary return, without any investigation of facts, will place him in a situation which he should not be expected to have to tolerate. He is not the responsible for the passage of time, but the passage of time has contributed to the situation. Now, in that case, the child was 8, had been in this jurisdiction from Romania for about 4 years by the time it reached the House of Lords. But in the courts below was not represented and was not a party.
Was this point put before the judge? Delay wasn't argued. The length of time that had passed was not included as a reason why it would be intolerable.
Yes, it wasn't put. I can confirm that. No, it wasn't.
Okay.
Not specifically put. And the question is for this court of appeal whether or not, again for the reasons I've set out earlier on, whether it has a duty to the child because of a delay of this magnitude, because there is a delay. Of course, Hakovich proceedings are supposed to take about 6 weeks and they're supposed to start within the year of the child's removal, or in this case retention, but still it's resulted in a great effluxion of time, almost 2 years, while the child's been putting down roots and has become integrated and has, of course, during the age of 6 to 8, has become more sentient. And in those circumstances, surely with respect to the child's views needed to be ascertained, and surely it's something that he shouldn't have to tolerate, a summary return, have to tolerate without the court considering that aspect of the Article 13b defence.
It was never suggested at the hearing that the child should be seen, and was it ever suggested before?
No, I gather it wasn't, and the reason it wasn't is because child's objections was not being put forward as a defence.
Okay.
But that's a different point, I respectfully submit, on behalf of the appellant, because of the delay aspect and the child's views on not only whether he should be sent back to Germany, but also in his habitual residence.
Okay. Does that deal with that your 13b submissions?
Can I just double check with my energy?
Okay. Just carry on. Just carry on with the equation.
Yes, well, what's being mentioned is what I've said earlier on about because of the father's conduct, recent conduct in breach of his undertaking.
Yes.
The court, which the court has to bear in mind, all of the soft landing, if I can put it that way, provisions are brought into doubt. And though the basis upon which the learned judge in the court below granted the application was on those undertakings, thinking that the father would, of course, adhere to those undertakings. Well, he obviously won't. And again, I know the court has read De Bene Esse, that letter, a very short letter in German.
But you've not applied to amend your grounds of appeal again to deal with this.
No, we haven't. But what we have said in the grounds of appeal is words to that effect. Because paragraph 7 learned judge failed to take into account whether the undertakings given by the father, particularly in relation to not removing the child from the mother's care before the matter was brought to the German court, could be relied on, given the findings in respect of wrongful retention of the child in Germany in 2019, his dominance over the mother, his insistence that the child is his child and should live with him, and his failure to make full disclosure to the court in respect to the messages between himself and his mother. And that's exactly what's happened here, of course, is that he has breached the undertaking not to remove the child
Well,
from the mother's care.
One course which might be taken would be that if this appeal is dismissed, is for the matter to go back to Mrs Justice Theis on your application to set aside her order on the basis of breach of the undertakings.
Yes.
And at which point she would have to consider whether to do that in the light of these subsequent events, having regard her overall evaluation
Her
of
overall
13B
evaluation,
defence.
indeed. Yes. But then the overall evaluation, if the learned judge was to decide that, we respect submit you should have the opportunity to have a look at the habitual residence point at the point of retention, wrongful retention as she's found it, specifically, because that would then, of course, establish, or not, the English court's jurisdiction over this child. Because those orders that have been made by Miss Justice Russell, Miss Justice Judd, for the father to return the child to his jurisdiction, the jurisdiction for those orders is possibly Section 5 of the Child Abduction and Custody Act. Child not in this country, but orders made about the child. There's an authority that's mentioned in the Red Book, which I can turn up the reference to, where under the Section 5 interim powers under the Child Abduction and Custody Act, the court made an order even though the child hadn't physically arrived in this country. So there's that jurisdiction potentially for the court below to make orders about the child's return, pending the habitual residence decision. And if the court finds that it does have jurisdiction based on habitual residence, then of course further orders can be made. If it finds it doesn't have habitual residence jurisdiction, then the German jurisdiction will be established. But the parties, of course, are legally aided within these Hague Convention proceedings. Father has automatic, non-means, non-merits tested legal aid. Mother has got legal aid to argue this habitual residence point if it's remitted for that as well as for the breach of the undertaking.
So,
point.
if the appeal is dismissed, the judge's finding on habitual residence in Germany stands, and she has no. Is your point? She has no jurisdiction to make any further order. Is that what you're saying?
No. What we would respectfully submit is for the order to be set aside on the basis of the breach of the undertaking, and for the court to revisit the issue of habitual residence at the date of wrongful retention. Because we respectfully submit that hasn't been dealt with.
Sorry, but the court could only do that if we allow the appeal, couldn't it?
It could.
The premise of my question is if we dismiss the appeal.
Yes. Well, if you dismiss the appeal, then it's simply a matter of enforcement and whether the order should be set aside on the grounds that the court can't rely on the father's undertaking. And if it's set aside, then it's the child is in a jurisdictional limbo because the Hague Convention proceedings order has been set aside, but the child is physically in Germany.
Well, theoretically, you could apply in Germany on the basis that the date of abduction, the child was habitually resident here.
Yes, but on that basis, we would probably apply under Article 15 of the Hague Convention to this country for a declaration that the child was habitually resident in this jurisdiction at the time, or worse to that effect.
So you have got a remedy then?
Potential remedy. Yes.
I'm sorry, I'm now getting very confused. My Lord's question was posited on the basis that the appeal was dismissed. Therefore, we would be saying the judge correctly, on the material before her, came to the conclusion she did. It's necessarily implicit in that her decision as to habitual residence being in Germany at the date of wrongful retention stands, and it doesn't seem to me to be open in those circumstances for that question, habitual residence in July 2021, to be revisited. What my Lord was contemplating was that because of subsequent events, the breach of the undertakings. That might make enforcement of the order open to question, which would be done procedurally by your applying to Mrs Justice Theis to revisit her order because of the breach of the undertakings. But that wouldn't in any way undermine, as I see it, her conclusions on jurisdiction and habitual residence in July 2021.
Which she would not be able to revisit.
Have I misunderstood,
Well, indeed, yes.
misunderstood the position?
I agree with that, Your Lordship, but of course I'm just thinking about July 2022. By the time of the...
Well, but how does
By
that,
the time
that
of the
doesn't
file's
go, that
removal.
doesn't go to jurisdiction, does it?
Well, by the time of the file's removal in August 2022,
It might go to your Article 13.
is not the child habitually resident in this jurisdiction, let's face it. And that would be a factual determination of the court below,
Sorry.
which doesn't interfere with Mrs Justice Theis' decision about wrongful retention.
I don't want to take up too much time with this, but so the premise is the appeal is dismissed. This is just a hypothetical question, so we can work out all strands. If the appeal is dismissed, and you want, that means the judge's finding about habitual residence stands. The judge's order for summary return stands, but you would be applying to set it aside, would you, on the basis of a breach of the undertaking?
And, with great respect, we would be saying the child, by August 2022, became integrated in the habitually resident.
Why is that relevant?
Well, that's relevant going on for jurisdiction for any orders for the child to be brought back to England for Hague Convention proceedings in Germany for the summary return of the child to England. Because otherwise the German court would say, well, this child has been found to be habitually resident at the time of wrongful retention in July 2021 in Germany.
Well,
But that's a matter for
I don't, unless my lords want to explore this further, I think we might come back to you after we've heard Mr. Gratian about that. But I think it would be a distraction to get down that track. Do you agree? Or do you want to have another go? Okay. Okay. Anything else?
Nothing else.
Thank you, Mr.
Great.
Gupta.
Thank you very much.
Mr. Gratian.
Lord, thank you. If it assists, I can say something brief about the propositions that were just explored with Mr. Gupta now on the hypothetical scenario that the appeal is dismissed
All right.
and an application is made. My lords, in those circumstances, in my submission, the mother could, of course, make an application to set aside Mrs. Justice Theis' return order. That would be a matter for her. In terms of substantive jurisdiction, which really I think is the key point that Mr. Gupta was driving at, in my submission, on the basis of Mrs. Justice Theis' key findings, which were that there was a wrongful retention in breach of the father's rights of custody at a time when the child remained habitually resident in Germany, substantive jurisdiction to make orders in relation to this child is retained in Germany as a consequence of Article 7 of the 1996 Hague Convention. Now, because really I think this point didn't seem to arise, at least on the substantive appeal, that isn't before you in the authorities bundle. But Article 7 of the 1996 Hague Convention retains jurisdiction in the state of the child's former habitual residence where there has been a wrongful removal or retention until such time as certain conditions are established. And those two conditions essentially are that each person, institution or other body having rights of custody has acquiesced in the removal or retention. Plainly that hasn't happened here. And secondly, that the child has resided in that other state for a period of at least 1 year after the person, institution or other body having rights of custody has or should have had knowledge of the whereabouts of the child. No request for return lodged within that period is still pending, and the child is settled in his or her new environment. And in my submission, because of the father's application for return, which
That doesn't apply. So in other words, your case is that Germany retains, if the judge's findings, this is what I was clawing my way towards, if the judge's findings stand and the appeal is dismissed, then Germany has jurisdiction
Yes.
to deal with substantive matters. And it would be a matter for Mrs Justice Theis on any set-aside application to determine whether that fact meant that she should not intervene further.
Yes, but more my point perhaps is that the mother's remedy here, in fact, is in Germany. And, my lord, if the mother's case is that the father, through taking the steps that he has taken, has acted contrary to the welfare of the child, in breach of undertakings or in breach of orders, then one can safely assume in my submission that a German judge sitting in a German court would take all of those matters just as seriously as would Mrs Justice Theis or another judge in the High Court in this country.
Thank you.
And well, that perhaps leads in to some of my substantive submissions, which begin, if I may, with what the Hague Convention is for and what it's due to decide, or what it's intended to decide. And I only raise this because it came up briefly, admittedly, in the course of argument. But as was identified, the Hague Convention is, at its heart, a jurisdictional instrument intended to identify and then to safeguard the jurisdiction that has primary responsibility for taking welfare decisions in relation to the child. Now, of course, for judges, practitioners, and most importantly, litigants in court, the most important part of that is the return mechanism. Because, as has been well established in various authorities now, the Hague Convention seeks to protect the integrity of the primary jurisdiction with responsibility for making welfare orders in two ways. Firstly, by preventing the courts of any other contracting state from making decisions about the custody of the child, and it does that through Article 16. And secondly, by providing a mechanism for the courts of the country in which the child has been wrongfully, or to which the child has been wrongfully removed, or in which they have been wrongfully retained, to order the summary return of that child back from whence they came. And my lord, it does that, my lords, it does that in a particular way by working effectively on the basis of presumptions. The key presumption being that it's in the child's interest to be so returned, or that it's in the interests of children generally to be so returned, if the applicant can establish what Mr Gupta, in accordance with common parlance, described as the Article 3 case. Firstly, that the left-behind parent had and was exercising rights of custody at the relevant time. That wasn't an issue in this case. It was accepted from the outset that the father had rights of custody, and secondly, that the child was habitually resident in that state at the time of the wrongful act. And if those points are established, then the burden shifts onto the respondent to establish one or more of the exceptions to return, which effectively work to rebut the presumption that it's in the child's interest to be returned for substantive welfare decisions to be taken about the child there. And my lord, that structure and the basis of the convention provides, in my submission, the key point of difference when considering how the court goes about considering and adjudicating upon a Hague Convention case, as between this type of case and a welfare case under the Children Act 1989, whether that's private law or public law. Because the safeguard that is always present is that there will be another court somewhere, whether it's the courts in England if the application for return is refused, or the courts of the requesting state that has the responsibility to make substantive welfare decision.
Yes.
My lord, that difference is why, again in my submission, whilst it is entirely accurate, and this is a long-standing principle, to describe Children Act cases as being quasi-inquisitorial, 1980 Hague Convention cases are different. And they are approached both through the relevant procedural rules, but also in terms of their conduct in court in a different way. far more adversarial in their structure, in a manner much more similar, although that's something I have only very limited experience of general civil litigation. My lords, it may not be necessary to go to it, but there is, within the authorities bundle, right at the end, recent practice guidance, which in fact really just mirrors the structure of the family procedure rules in this regard, that sets out the process of the pleading of a case under the 1988 Convention, which includes, as another key point of difference between these types of proceedings and Children Act proceedings, an obligation...
Should we look, yeah, I was going to say, should we look at that?
Yes.
Because the Lords may not have seen it, and I'm sure I've seen it, but not for a long time.
It's at page 567 of the authority.
567. Tab 20.
I have an electronic version with no tabs, so I'm afraid I can't.
It's the practice guidance.
It is the practice guidance.
So this, just remind myself, this is guidance given by the President?
Yes. In March of 2018.
By the previous President, not that that matters.
Which sets out a series of steps that are taken in different contexts in 1988 Convention proceedings. And the first part, which sets out the structure, in my submission is at 569, which is directions that are to be made on a without notice application. Paragraph 2.5 sets the preamble. The directions given will include the following, so it's mandatory. And then in this particular regard, at subparagraph C, a direction pursuant to Rule 12.52A of the FPR for the filing and serving of the respondent's answer, which my Lord Justice Baker referred to earlier as a defence, which is what they used to be called.
Okay, all right. You're showing my rustiness. But, and often this is done without, is this done without a hearing?
Yes. So if
That's the new streamlined process.
it is,
To avoid the multiplicity of unnecessary without notice hearings.
indeed,
People we don't dealt with on the papers by the applications judge or whoever.
yes, and an order in relatively standard form is made, which includes these directions, and that's simply served on the parties by sending it out to their solicitors. Or alternatively, directions of this nature are made at a without notice hearing if the case justifies.
They sometimes do come into court, don't they?
Yes.
Yes?
And in fact, Lord, as you've mentioned it, the standard directions on issue are dealt with at the following page at paragraph 2.9.
Is that right?
And includes also at subparagraph C,
See, yes.
same requirement, top of page 571.
Okay, so 2.5 is if it's without notice at a hearing.
Yes,
2.9 if it's on notice, then it usually is without a hearing.
and dealt with on paper.
Yes, thank you. That's the point.
And then just
See,
for,
yeah.
for completeness, at 2.11, there's directions at first on notice hearing, which of course assumes that the prior steps have been taken, and so deals with other matters.
2.11, did you say?
Yes.
Yes.
And the language there at the conclusion of the introductory paragraph is different. The court will expect the parties to be able to deal with the following case management issues if applicable. And the relevant part of that in my submission, or particularly relevant part bearing in mind some of the submissions that have been made today, is subparagraph H on page 572, directions with respect to ensuring that the child is given the opportunity to be heard.
Okay.
So there is a clear structure, both under the rules and within that guidance, as to how the case is to be pleaded and what documents the parties are to file. But the most important of those documents, in my submission always, is the answer, because through the answer, the respondent sets out the issues that they take with the case that is advanced against them.
Can we just look to see in these directions in 211 how it's supposed to work at the first notice hearing? So the respondent has filed the answer, and then I'm just going through it. D, directions with respect to the filing and service of the answer, evidence in support, to include details of any protective measures the respondent seeks.
Yes.
So, including undertaking. So this is envisaging typically the 13B defence and, as it were, early warning or early identification of protective measures, which are such as undertakings of the sort in this case, which are commonly included in return orders.
Indeed, although one can see from paragraph 2.9d, the standard directions on issue, that if everything has gone as it should and parties have complied with the directions that have been made,
It's raised earlier.
it should have already been done.
You're right.
2.11d is really, I suppose, a catch-all to provide for those situations where, notwithstanding earlier directions, that hasn't been done.
Do we know in this case whether directions were given under 2.5 or 2.9 or 211?
Forgive me, my lord, I'm just turning it up.
You mentioned the judgment.
In this case, there was a first on-notice directions hearing. So there was no without notice directions.
So we should be in 2.9 territory.
No,
No?
because 2.9 is directions on issue made on paper. This case seems to have been listed straight for a first hearing, so it was 2.11
So it's 211.
territory.
And do we have the directions order made?
We do. Well, forgive me, I'm in one of the other bundles at the moment. Let me just turn up where that is. So it's within the respondent's supplementary bundle at page 33.
Oh, that's right. This is Judge Robertshaw.
Yes, or on a Judge Robertshaw. From that, one can see both parties represented at that hearing by counsel. We have at paragraph D of the recitals the statement of the mother's case, and this is the first statement of the mother's case that I've been able to identify.
Right.
Provided in lieu of an answer, no mention of a challenge to habitual residence in any respect, reliance only on consent, acquiescence and Article 13b. And then at paragraph E, we have the mother expressly disavowing, as it were, reliance upon child's objection. So there has been consideration of the basis upon which the mother is defending the case and upon child's objections and the need, therefore, to hear the child. And then the judge makes directions that primarily at that stage are directed towards what might be described as an asylum issue.
Yeah.
But, my lord, in essence, that aspect of the case fell away because the country from which the mother had claimed asylum was Uganda. There was never any suggestion that there should be a return there. And so on the basis of G and G, this wasn't really a case that engaged the principles that arose there.
That was it. Initially, it was thought it might be.
Yes.
Yeah.
It was thought that it might be, but the basic principle in G and G, of course, is that one can't refoul the child or a carer of the child to the country from which they are a refugee.
Yes.
And in this particular scenario, because the return was to Germany, not Uganda, the principle of non-refoulement isn't engaged, the principles on G and G are not engaged,
Yes.
and therefore the directions in relation to the involvement of the Secretary of State, etc., soon became, or it was appreciated after this hearing, that they became an irrelevant consideration.
Were these agreed directions?
I don't know, I'm afraid.
I mean, they must have been substantially agreed.
Yes, they're not recorded as being by
No,
consent,
but
but equally.
these are Mr. Bennett and Miss Duncan's draft.
Yes.
Plainly.
Yes.
I would have said.
Yes.
Can I incidentally make a very minor point which I've made before? What we've got in the bundle is headed draft order and doesn't have a seal on it.
Yes.
And orders really ought to be sealed before they're finalised. It seems to be a practice to omit the finalisation and sealing of the order, which means that you have things marked draft orders and people can't always be 100% sure that has been approved by the court. You're probably not in a position to help, but it's just it's a pet grievance of mine that we're constantly asked to look at things which are not sealed orders.
Yes.
We really ought to be given properly sealed orders. Anyway.
Somewhat dispiritingly, Miss Papazian tells me that we have never in fact received a sealed version of this order,
No.
which standing
Well,
here 10 months or so later is an extraordinary position. But
Well, if this is a problem in the family division, I'm not sure whether the Lord's comments are reserved for the family division, but we've certainly seen it in similar cases. Something needs to be done about it.
it is something that comes up from time to time.
Well, you might mention it to the relevant users group.
Yes,
Mr. Justice MacDonald,
I certainly can
or
do that.
indeed Lord Justice Moylan. Moving on. Okay, so that deals with that point.
That
So
deals with that.
That's helpful.
In relation to that, the important direction, those dealing with the Secretary of State having fallen away, is that per paragraph 3,
Yeah.
the mother is directed to file a witness statement attaching any and all evidence upon which she wishes to rely, including the protective measures point that arises from the guidance. And a further hearing is then listed on the 16th of December. I think there is then some slippage in that timetable,
Yeah.
but the mother does in due course file a statement. Lord, forgive me. Before we get to that, I just wanted to draw attention to one other document in terms of how the case was set out at the outset, which is in our supplementary bundle still at page 20.
Page
Which should be
page
section
20.
4 of the father's central authority application.
Now, I don't think I've got that.
Oh, I'm sorry, my lord. It should be there.
I'm looking at the respondents' supplementary bundle. Page 20.
Starts 4.2, address of a child.
Yes, that is right. Well, that's what I have that document at page 20. The first page of it in translation.
I mean, those of us looking at hard copies, we're struggling.
The bundle I have, a lot of things have been deleted.
Yes.
So the bundle starts, in fact, at page 33.
With that document, with the order we've just been looking at.
Right. It's the German Central Authority application form. In
Yes, I think there's a difference between the electronic bundle, which I'm looking at.
It might be page 68. It seems extraordinary that at 12:45 a further issue has arisen in relation to these bundles, and I apologise for that.
Well, page 67 is a request for return.
Yes. That's the
We're
document.
on the right page.
That's the right document. And then the particular part of that document
Oops, that's right. Top, not off. Good.
is
Page
section
67
4.
of ours SB is the request for return.
Yes. That's
So
the
that's
request
the
for
request put.
made by the father to the German Central Authority for transmission to the ICAC.
So this is a German-produced document.
Yes.
It translated and sent to the ICAC.
Yes.
AU.
And
ICACU.
the original German should precede it in the bundle.
Okay, well.
Section 4
Yeah.
just sets out the father's case as to time, place, date and circumstances of the wrongful removal or retention. And he, within that, pleads two possible dates, January 2021 and July 2021. took rather a long time to make
Page 69, Roman 4.
Roman.
Roman 4, not. Okay.
That document came into these proceedings exhibited to the statement filed by the father's solicitor when he issued his C67 application.
Okay. Right. Now you're taking us to the mother's statement.
Yes.
are you?
So, my Lord, I fear, because this is within the same bundle, that my pagination for this may be different to yours again. Mine is page 47. Or it may be 188.
What's the date of it?
It is
15th of February.
Yes.
yes.
188.
No, my Lord, sorry, it's not a February statement. It's the 21st of December, filed 23rd of December. So I have it at page 47.
That statement is shown as being deleted.
It's been deleted from our bundle.
You have the original trial bundle. I don't understand.
We have that. Have you got that?
I'm looking on the electronic bundle. which
Is it
I-
there?
Which it is there.
Okay. Well, when was that sent to us?
I think this was sent on Monday.
Okay.
This is yours.
Have you got the computer?
I'm just having a look now.
Your client's statement. 23rd.
Sent on Monday.
Yes.
I should say I'm very grateful to Ms. Jones for forwarding the documents earlier this morning. So Monday,
I've got a lower court one.
is it the lower court bundle?
It's the title that I have for it is Supplementary Bundle.
Okay.
And I think it was sent together with the application for the court to admit this bundle and to consider it.
Right. That has been put for me in the OneDrive.
23rd December. Somewhere else.
Okay, so it's in the core bundle.
No, supplementary. Is it this? This is in our supplemental bundle. Okay. Yeah. There's 47 of our supplemental.
All right. Mr. Gupta has it at 47 of the appellant's supplemental bundle.
Right, if you just bear with us a few more seconds, have you got it?
Yes.
So, what page in your supplemental? 80.
It starts at page 47. The relevant paragraphs are on page 49, and it's just paragraphs 11 and 12.
Well, my Lord Lord Justice Phillips hasn't got it.
Perhaps we're coming up, I think, shortly to lunch.
This isn't going to work because I've tried to get it and I can't open it.
Well, perhaps over lunch we can send.
Send
A link
the
to
relevant
download
document
this.
through. Okay. So what's the point you want to make about it?
This is where the mother sets out, in the form of her evidence, what her case is about why or how she's defending these proceedings. And, well, my basic point is that all that she asserts through those paragraphs within that evidence is that the father had agreed to the child staying with her in England. The father having brought the child here in September 2020. And then by paragraph 12, she states that the child has settled status in the UK under the EU scheme.
What is that a reference to? This is post-Brexit arrangements for EU
Yes.
citizens.
Yes,
He is a German citizen, isn't he?
yes.
Does that affect anything in relation to the Hague Convention?
No. The point that I'm seeking to make through referring to these is really the paucity of evidence provided by the mother in support of her case. There is very little in relation to even the discussions and agreement that she asserts were reached pursuant to which the child came here, she says, permanently. There is really nothing that could be said to be evidence about where this child was habitually resident at any particular point in time.
What was your evidence about that?
The father's evidence
We have the father's original statement.
yes. So, Lord, the first evidence that the father relied upon is the statement from his solicitor, Amy Ayling,
Yes.
which is the first document.
We've got that in this hard copy bundle,
Yes.
page 50. Yes.
So within that statement, on the third and fourth pages,
Paragraphs.
beginning at paragraph 8, and then through to paragraph 14, the father sets out, or the father through his solicitor sets out, the father's case in relation to the agreement that was reached and the limitations on that agreement. The limitation on contact that has been, on the father's case, imposed, paragraph 11. Paragraph 12, very briefly, I accept, the child's circumstances in Germany, living with the applicant and his older son, happy in Germany where he was due to start school.
Okay.
And
So there's some
of the-
factual points here,
Yes.
assertions, but nothing, no express reference to habitual residence.
No, my lord, but this is the evidence
Material
the father
upon,
relied upon in support of his contention that the child had become and was habitually resident in Germany.
Can I go back to
Yes.
when you were showing us the practice direction, whether under 2.5 or 2.9 or 2.11, it draws a distinction between a document called the respondent's answer and the evidence in support.
Yes, it does.
It doesn't here appear to have been any directions for an answer as such. Was there ever one filed?
Well, we're going to come to that.
I see.
That seems to have slipped through the cracks at the earlier stage, but Mrs Justice Theis, when she first became involved in this case, which was in February, in the context of what was an abortive final hearing, directed the mother to file an answer. And we have that document, and I am going to go to...
Thank you.
I'm just going through it in stages so that...
No, it was just I was concerned I'd missed something. But
Yes. And what I'm hoping to do by the end of all of this is to show how the mother's case was pleaded throughout and to draw a distinction between that and the one part where the mother, through Miss Jones, actually made reference to habitual residence, because that, in fact, is the only place in all of these papers, over 500 pages, where that assertion is made on the mother's behalf.
yeah, okay.
But that's accepted, as I understand it. You can take us through it all. I'm not sure that the contrary was put forward. I think really what the gravamen of the contention you meet is simply that the judge had some overriding duty to say, well, actually, was the child habitually resident in England as of the date of retention, even though that wasn't expressly put forward in closing submissions, on the basis perhaps of the references in the position paper and in the skeleton.
Yes.
And it's not suggesting that there was any further material that was put forward to support it, and indeed it wasn't referred to in closing or...
No.
So,
Well-
whilst it may be useful for you to do that exercise, and I think you're tilting at a non-existent windmill there.
Well, my lord, I appreciate this perhaps is becoming a somewhat laborious process for which I apologise, but the way that the case was put consistently and throughout all of these documents really, in my submission, directly leads to, and I appreciate this is maybe a point on which there isn't much opposition either, but leads to the way that Mrs Justice Theis dealt with the case and adds support to the contention that she was, if there was a general obligation for her to investigate things that weren't expressly put before her, and I don't accept, for all the reasons I've given and for the reasons given in our skeleton argument, that there was, in circumstances where all of the mother's other documents put the case in a certain way, it must give the judge far more support for dealing with the case in the way that she did, and not for dealing with a point that was really, it seems, put in a somewhat throwaway manner in the skeleton argument and not then pursued in the way that Mr Gupta suggests she was
Mr Gupta said
required to.
expressly that there was nothing wrong with her judgment and she can't be criticised, but her decision was wrong.
Yes.
That's exactly the way he put it, is that you can't criticise the way she dealt with it, given what was before her, but nevertheless we should say that she was wrong.
Yes.
Now that seems to me to be the contention that you have to deal with,
Well, Lord,
to the extent it needs to be dealt with.
I mean, I think we're all right, but for my part, I'm interested in what you're going to tell us at some point about how the specific steps taken by Mrs Justice Theis.
yes.
Because, well, let's leave it there.
So, shall I do that at 1 o'clock?
Do it at 2 o'clock.
2 o'clock. I'm very sorry.
We do it at 1 o'clock too, but we won't be here to hear it. Roughly how long do you think you're going to be?
Well, I'll try and keep it as short as I can. Not more than 45 minutes.
Okay, good. That's fine. Thank you very much. We'll see you at 2 o'clock.